Hey, are you feeling all right? Still alive and kicking? Not quite 6 feet under? Great. Perfect. You're the right person for this podcast today. But guess what? We don't all live forever. Actually, I don't guess any of us really do, unless you're a demigod or something. And I don't know any of those. Maybe you do. So if you're mortal, like the rest of us, you're going to want to stay tuned today because there are legal actions you need to take to protect yourself, your assets, and the future of your heirs. That's right, your heirs. People that live past you who will inherit your property. Where's it going to go? Who gets it? Why? How come? We got questions. And today, my special guest is an estate attorney. So here we go. We're going to talk about legal stuff today, but it's important. So stay tuned. Hi, I'm Honey Gregory. Welcome to my channel, Perpetual Learning, where we are continuously learning every day. So, you know what I always say, if you're not learning, you're dying. So hopefully my mic is working today. I have a very special guest today that I want to welcome everyone. My good friend and colleague, Stephen Douglas, who is a wills and trusts and estate planner and a former attorney general for the state of Indiana. Welcome, Stephen.
Thank you, Michelle.
Well, I
Good
hope
to
you
be
can
here.
hear me. I've had computer problems, as you know, today. I don't know what's going on. Oh my goodness. Well, I appreciate you taking the time out of your busy lawyer day to come on here and give people information. But, you know, you and I have talked before and you did my other podcast, and you were so great at explaining the importance of estate planning in general, as well as if you're going through a divorce or recently divorced. So why don't you just give us a little bit of your credentials and then we'll help people out.
Okay, well, credentials, I'm not sure, other than the law degree, it would be applicable, but I have a couple of degrees in education. I've taught at several levels, including the college level, for a period of years, and I've been an attorney for quite some time now. Started out as a deputy prosecutor and then worked as a deputy attorney general way back in the Steve Carter years. So that's been a while. And I've been in private practice now for 18 years. And the majority of my practice is helping people establish some estate planning. We also do some probate work, new business startups, and things like that. I do a lot with contracts, which is kind of interesting because I started out pretty much as a litigator exclusively, and probably 80% of my practice now is what I would call desk law. Uh,
Desk law.
desk law. I'm not in court as much as I used to be, although lately it seems I've been in there quite a bit. But uh, generally speaking, most of our work is done here in the office. We have our clients come in, we hear what their concerns are, what their needs are, what their wants are, and we try to tailor their planning uh, to meet those needs, wants, and desires, and to make sure that what they want to have happen to their assets after they pass away is what happens. So, estate planning is probably about as much an individual thing as anything you pretty much get in law.
Yeah, yeah, it really is. And it has to do with everything that's going to happen once you've passed. So it's about getting everything all set up. So, why would that be important for someone to go ahead and set things up now? Because a lot of people don't have wills
Depending on what you read, I've seen studies where it's 70%
that don't
uh,
have wills.
don't
Wow.
have. The thing that I like to tell people, it's really kind of a labor of love. Uh, Nobody wants to think about dying. Unfortunately, it's something that we're all going to do uh, one day.
Hmm.
Some go quicker than others. Uh, my story really kind of revolves around two men that I greatly admired and loved dearly. One was my paternal grandfather, and the other was my father. My paternal grandfather lived to be about 80 at a time when living to be about 80 it wasn't unusual, but it wasn't something that was expected. My father died at 46. So, uh, obviously
That's really young.
you have almost a 40-year difference there as far as when the time they passed. But one thing that they both had in common was they had some comprehensive estate planning in place.
Mm.
For my dad, it wasn't as big a deal as it was for my grandfather,
Mm.
uh, because I just have one sibling, and so he left everything to my mom and my dear mother, who's still with us and will celebrate her 91st birthday this year.
Wow, that's fantastic.
Yeah. Um, but then it was just my kid sister and myself.
Mm.
So it's kind of like goes to mom. If mom's not around, it comes to us. Uh, my paternal grandfather, a little different because he had 11 children
Oh, wow.
and he had about a sixth grade education. He was born in 1903.
Wow.
But even someone that would not be considered sophisticated
Yeah.
by any stretch of the imagination, certainly not well educated, although he was a very intelligent man, saw the need to have some things in place because he was a farmer. Uh, his major assets were land and farm equipment,
Yeah.
and those just simply couldn't be divided like you can divide cash. So, um, one of the things that he did, we actually had an attorney where I grew up in Sumner County, Tennessee. His name was Bobby Goodall, and he kind of handled everybody in the family, so to speak. He's
Wow.
got a family attorney. And he sat down with Bobby and they worked things out. And when both he and my grandma passed, she passed away in 87. Uh, Everything went surprisingly well. I mean, it was a smooth transition. Uh, by the time both my grandparents had passed away, uh, they had been predeceased by four of their children.
Wow.
So it came down to the grandkids and things like that. And when we were all alive, there were 30 of us.
Oh, my
So
goodness.
it, it could have been messy. It really
Yeah.
could have been messy, but there was no messiness to it. And yes, my grandparents had to spend some money that they probably would have rather spent somewhere else, but they saw the need, and they didn't want hard feelings or anything like that. And sadly, when you get people together in a familial unit,
Mm.
um, I always hear this when clients come in. Oh, we don't have to worry about this. My kids get along.
Mm.
Um, so sad, but so true. A lot of times, once the parents are out of the way, and they're gone, then animosity seems to creep in. And I've seen families absolutely destroyed for less than $1,000.
Oh, my gosh.
So it is something that everybody should look at
Mm-hmm.
and be aware of. And the other thing that I'll just say from a cost benefit analysis, having an estate plan when your estate goes into probate, uh, having an estate plan in place, having a will in place, is going to cheapen the expense, lessen the expense of the administration of the estate. If you have some things outlined as to how you want things to go, as opposed to an intestate estate where you're going to have more expense and a lot of times more problems. So,
Well, when you're talking about more expense, you're talking about more attorney fees, trying to get it situated and figured out.
sure. And not only that, I mean, if you don't delineate, for example, items of personalty, like the grandfather clock that's come down through the family for, 100 years,
Yeah.
um, those assets a lot of times can be passed in the will without any real, you know, uh, stringent evaluation.
Mm.
Sometimes you need it. Depends on the circumstances. But if you're dealing with an estate that has no will, uh, then you're dealing with the tables of consanguinity. So you're having to figure out who gets what and
Mm.
and what percentage they get it. and valuation then becomes important. So you're probably going to spend money on an appraiser that's going to have to go through and appraise everything for the most part. Uh, a lot of times intestate estates are going to be supervised, so that's more expense because you're having to report to the court quite often, and it just makes sense to spend the money now. It's kind of like an ounce of prevention is worth a pound of cure.
Yeah,
So
absolutely.
that's one of the things that we stress to people. And again, I understand nobody wants to talk about dying or think about it,
Right.
but the reality is it's going to happen. And the question is, I guess, how do you want to be remembered by your children and your grandchildren? Do you want to be remembered as somebody that had things lined up where everything went smoothly and there was no acrimony, or do you want to be remembered as the match that lit the powder keg that blew the family up? So yeah,
Yeah.
it's not that simple, but there's a lot of that to it.
It's really sad because people just turn ugly. I mean, it's like same in divorce. It's like, oh, everything's mine. Mine. I deserve everything. Me. And I've talked to other um estate attorneys, and and you and I've had this conversation many times, and it gets really ugly, and it turns the family against each other. Like a family that loved each other, had family events, and got together on Easter and Christmas, whatever, now are not speaking to each other like forever. It's um, over grandma's china or something really silly. It's really
Well,
sad.
and when we talk about estate planning, I get this a lot. Well, can I just go online and download a form?
Mm.
You can, sure. Is it going to be cheaper? Yeah. I mean, um,
But is it going to hold up in court?
well, here's the thing. I always tell people, uh, when a lot of these online services came out uh, several years ago, I said, don't do this, don't do this, don't do this. Uh, from a selfish point of view, I said, go for it because I'm going to wind up making about 3 times the money sorting everything out. Uh,
Nice.
if you'd come to me first, and just little things. I'll give you an example. You may have an antique. It's been in the family forever and a day,
Mm-hmm.
and you want one kid to get the antique. One of the things that I always try to do, and I've tried to educate myself a little bit on this, is knowing what type of stuff has actual monetary value and what has sentimental value.
Mm.
Sentimental value both can operate against a harmonious, estate,
Mm-hmm.
but sentimental value doesn't translate to dollars.
Mm.
Um, had this client had this clock,
Mm.
okay, and this clock was hundreds of years old and
Wow.
still worked. It was
Wow.
an old mantle clock. It was made in England, and we, we're talking about who gets the clock, and there were multiple children, and they wanted this one kid to get the clock. And I said, do we have any idea what this clock is worth? Uh, no, it's just come down through the family. And I said, we probably need to get that clock appraised.
Yeah.
I said, I just have a sneaking suspicion that that clock's worth something. Well, as it turned out, the clock itself, just the clock, was worth more than the rest of the estate combined.
Holy moly.
Yeah. And they eventually wound up selling the clock
Mm.
uh, because, I mean, the deal was the person that wants to get the clock, you're going to have to come up with some money to compensate the other people.
Oh, wow.
So I just suggested, I said, look, if we're having a problem with this, it may just be a good idea to sell the clock because we had a buyer
Oh, yeah.
that was willing to pay top dollar for the thing. And I said, money
Wow.
splits easily.
Yeah.
You can't split the clock.
Yeah.
So, eventually the clock wound up selling, which was a good thing, and things turned out all right. But it's different stuff like that. Classic automobiles is another thing. Well, Grandpa had this, this chassis of a car out in the barn.
Mm.
So I started asking questions, well, what kind of car was it? And occasionally somebody will say, well, I think it's a 57 Chevrolet.
Mm.
Well, unless the thing is completely rusted out and just junk,
Yeah.
there are a lot of collectors that will pay big money
Oh,
uh,
yeah.
for a classic car. So sometimes it's a matter of just talking to the clients, figuring out what they have,
Hmm.
um, what it might translate to in terms of monetary value, and then structuring the estate plan in such a way that um, that everybody gets what the testator or the testatrix uh, wants them to have, and hopefully to sometimes we have to soothe some bruised feelings as well. So
Mm,
those are things that we try to do, and it's a uniquely personal practice of law. It really is, because you
yeah.
find out a lot of stuff about family dynamics.
Like you don't really want to know, but you got to know.
Oh, I've literally had people come in and say, this kid is a, you know,
Beep.
yeah,
Beep.
this grandkid is going to cause you trouble.
Oh
Uh,
boy.
one of the things that we do, I do have, I've used a videographer in the past. And if there's some question, if the client is elderly
Mm,
and there may be some question about their capacity, their mental capacity to be able to execute a will,
yeah.
we'll actually, I don't know what the term is now, we'll record it.
Hmm.
I always say videotape.
Yeah.
We don't do that anymore, but we'll record it. And so that, if it does go into litigation, a judge can see that this person certainly knew what they were doing when they executed the will. And so things like that are things that we offer people that maybe other people don't. Um, and again, we also try to involve the client as much as possible. So we'll do our initial drafts based on our first meeting with a client. We'll bring the client back in. A lot of times I just give them a red pen and say, go to it, tear it. And then when they've had a chance to do that, we sit down and we talk again. It's like, okay, you've marked this through. Tell me why you're marking this through, or what do you want changed there? And
Hmm.
so each will, there are certain legal parts that are pretty much the same, but the actual bequest, what you give to somebody or are giving to somebody or want somebody to have, those are very unique
Yeah.
to the client. So that's
So
what we
how?
try.
Oh, yeah, and I recommend people all the time to you, and everybody says you do a great job. But what if someone wants to cut someone out of the will? Like, I don't want my grandson to have anything. So can that be done?
Yeah, it can. There are a couple of ways you can do it. You can put a disinherit clause into the will.
Hmm.
A lot of people do that. That's no guarantee that the will won't be challenged.
Mm.
Um, some people put a clause in, that if anybody challenges the will, then they're written off. Uh,
Wow.
but
Is that
ultimately,
legal?
I mean, courts are somewhat divided on it, and
Yeah.
sometimes it just depends on the judge. But ultimately, what a lot of people don't understand, they think a lot of people that don't like what the will says, they'll come in and they'll say, well, grandma wanted me to have this, and she told me she wanted me to have this. And I talk to these people and say, well, that's not what she told me, and that's why it's not in the will. And
Yeah.
this is what she approved. This is what she signed. Well, she was off her rocker. She didn't know what she was doing.
Yeah.
Well, one of the reasons that we do witnesses, and I provide the witnesses, and they're legal professionals, is that we realize we may have to testify in court as to the mental capacity of the person.
Yeah.
Another area is undue influence, that maybe a child or a grandchild or somebody like that kind of worm their way into the mind of the testator or the testatrix and influence them to do things in their will or estate plan that they wouldn't normally have done,
Hmm.
uh, that kind of thing. But what a lot of these people that challenge wills don't understand is that the presumption at law is for the will.
Mm.
So you start out, it's kind of like in family law in the state of Indiana, when you're dividing up marital assets, the presumption is a 50-50 split.
Right.
Okay. Now, that doesn't mean you're going to get a 50-50 split, but you have to overcome that presumption.
Yeah.
It's the same in estate planning in large degree, because if you're challenging a will, you're going to have to overcome the presumption that, that the will is valid, that the will is in fact the desire of the testator or testatrix. And that's not easy to do. The challenger is the moving party, and they bear the burden of proof. So a lot of will challenges fall flat on their face, because just because you didn't get what you wanted doesn't mean that the will isn't valid.
Right.
And then the other thing that a lot of people don't understand, in the vast majority of cases, if the will, judges don't like to rewrite wills. So one of the things that they'll do, if a will is successfully challenged, they just toss the will, and they treat it as an intestate estate. So statements of consanguinity come into play. Here's a classic example. Mom dies. She's a widow. She has 2 kids. And she leaves everything to the 2 kids to be split evenly. All right. Well, one kid wants more,
Of course.
So they challenge the will, and let's say that the challenge is successful, and the judge tosses the will for whatever reason, maybe lack of capacity or whatever. Well, then the estate is largely going to probably proceed along the lines of intestacy. And if you have the 2 daughters, they're going to split it anyway.
Yeah.
So all you've done in a lot of respects is to just increase your cost.
Yeah.
Now, I'm being very, very basic.
Right, of course.
But
they could also have some other relatives that suddenly come into play.
There are possibilities like that. The tables of consanguinity basically go up and down before they go side to side.
Okay.
So
always go to the grandchildren before any brothers or sisters would receive
pretty
anything.
much, yeah.
Okay.
Because, everything is delineated by statute. One of the things I always tell people, when they say, well, just go to my kids, right? I usually ask this question: are either of your parents still alive? Oh, yeah. Well, if you die, your kids are not going to get everything, because if I died and I didn't have a will, I mentioned my mother earlier for a reason, to get to this point, long way around the barn, but I finally got there.
That's all right.
If I were to die today without a will, I have 3 biological children, and it would seem that they would inherit everything. Not so. If I died without a will, my mother would get a percentage.
Yeah.
Because she's still alive and she's in that lineal, and it goes up and down.
Yeah.
So, it's
wow. Yeah, it's best to go ahead and take care of it while you're alive, to try to help your family stay friends. But what about in a divorce? Now, I get it, all the time. I'm always telling people, as soon as they come in my office and say, I want to file for divorce, I'll say, do you have a will? And we talk about, beneficiaries, if they have one, and when they can change it.
You just froze on me, Michelle.
Uh-oh, not again. Can you see me? Can you hear me? Oh, you're frozen. Dang it. What's going on with this? This day. What's happening? Hello? Hello?
I can't hear you. You're muted.
I don't know why it's doing this. Okay. It's just acting really weird. I'm sorry. I'm cutting and splicing the last one because this kept happening. So we're talking about divorce. So I have people always, like I was saying, come to me during divorce, and I always ask, do you have a will? Do you already have beneficiaries? We can't change them, blah, blah, blah. But a lot of people don't have one. So I'll send them to you. You probably get people call me up saying, Michelle sent me. So me telling them to come to you and start thinking about what they're going to do and get prepared, so that when the divorce is final, they can sign on the dotted line and know that their spouse isn't going to get everything.
Yeah. One of the things that we encourage people to do in the case of a dissolution is to review your estate plan, and that doesn't just include your will. Okay. That would include anything that you have that would have a beneficiary designation on it.
Like
an IRA or like a life insurance policy.
Okay.
401k, something like that.
Right.
A lot of couples name their spouse as their primary beneficiary.
Right.
And a lot of those policies don't have a rider in it that says that in the case of a dissolution, it goes down to a contingent beneficiary. They don't have that.
Mm.
So you need to make sure you're getting in touch with your financial planner, your insurance carrier, your HR department where you work. And if you're self-employed, you need to, really pay attention to what's going on and make sure you get those beneficiary designations changed,
Mm-hmm.
because we have seen circumstances where they weren't, and then the principal dies. The new spouse or the children are expecting, a pretty significant payout, and they find out they're not getting it
Mm-hmm. Mm-hmm.
because
Yeah.
the beneficiary designation wasn't changed.
Yeah.
Just because a person is divorced from somebody doesn't mean that that person won't get the benefit of those policies, life insurance, 401k, or what.
Not again. Oh, God. This thing is driving me nuts today. Oh, my lordy. Anyway, as we were saying, so they have to look at so if they're going through a divorce or just got divorced, they need to come see you ASAP so they can talk to you about their beneficiaries and subsequent beneficiaries if everybody dies at the same time, right? So, but a lot of times, I tell people they also might want to consider a trust, especially if their kids are like really young, right?
You can do that in any number of ways. The thing that people need to understand is a trust lives on after they do.
Mm-hmm.
So sometimes if people have minor children, uh, they can actually set up what we call a testamentary trust in the actual body of their will document. Um, it's not as extensive as what you might find with a, a very comprehensive revocable or irrevocable trust, which could be scads of pages. Usually we do a testamentary trust in just a few pages in the will, which will outline the terms and conditions of the trust. The other thing that I would tell people, if you have a a minor child or minor children in your estate plan, is you really need to have some kind of guardianship provision in there for them. In the case of a dissolution, unless there's something else going on, more times than not, the children are going to go to the surviving spouse.
As long as they're not having supervised parenting time. Yeah.
Yeah. But, assuming that, you do have a problem, you really don't want the court being the one to make that decision.
It
And
doesn't hurt. You always find that it doesn't hurt to have something in there and an explanation why you've named that person just to give the judge something else. It can be presented. It just gives the judge a little tidbit that he might not know otherwise.
it does help.
Yeah.
The last couple of years, I've had several people come in that have siblings that have children of like age to their own children, and they've agreed to undertake guardianship duties if that circumstance should arise. That usually tends to be a pretty good working solution, simply because it keeps, for lack of a better term, the orphaned children within the greater family unit, and gives them a kind of a bedrock that they can stand on, which is a good thing. But there are also, again, when we talk about estate planning, it's just not wills, it's not trust, but it's getting down to the nitty gritty about what somebody, wants or needs, and considering a lot of different alternatives. And there's some very good attorneys out there that do that.
And there's other things where you can pass property, land, homes, vehicles, and things like that to people using that. What'd you call it? You told me once before. Was it called the transfer on death deed or something like that. So it
You can do
completely
that.
bypasses the will and probate or anything that might happen. So sometimes that can be helpful too, because then that way for sure it's going to the person that you want it to be designated to.
Yeah, and another thing that we also can do is do a deed that lists another family member as a tenant in common with the right of survivorship.
Yeah.
Um, so there are all sorts of different things. Again, there's more nuance to it than we have in 30 minutes to
Yeah.
discuss. Um, but at the same point in time, what we try to do is make sure that you know the wishes of the person that actually owns the stuff
Mm-hmm.
is what actually happens.
Mm-hmm.
Um, One of the things that I've been doing a lot recently, it seems like, is doing a lot of renunciations.
What is that one? That one doesn't ring a bell.
That's where a person renounces any right to inheritance.
Oh, okay. Okay.
Uh,
Really? They say they don't want it. Because there's tax consequences, or why is that? Why do
well,
people do that?
not so much tax consequences anymore because the federal estate tax doesn't kick in until you're up around $13 million or
Oh,
whatever it
okay.
is. And Indiana abolished its inheritance tax.
Nice.
There could be other taxes that might be applicable, but I won't get into that because I'm not an accountant. Uh, but for example, maybe you have a sibling that's special needs,
Mm.
and mom left everything to be split between the two of you, and you're in a good financial position, and you don't need the money or you don't need the stuff,
Mm-hmm.
and you want that to go to your special needs sibling,
Yeah.
then you can renounce your inheritance.
Mm.
Uh, thing people don't understand is this: you're not obligated to accept an inheritance, um, and you are not entitled to get one. Uh,
Yes.
we deal with the latter rather than the former more
Yeah.
because everybody thinks they deserve a piece.
Yeah, of course.
Um, and one thing that ticks me off more than anything is when I hear a entitled child or grandchild come in and say, "Well, Grandpa or Grandma, don't do that. You're spending my inheritance."
Oh,
That sets me off.
yeah, I'm sure.
Usually, at that point, grandkid or entitled kid is leaving the conference room.
Yeah, right.
But no, I mean, you can, again, as long as it falls within the confines of the law,
Yeah.
um, we have a lot of flexibility on what we can do. And so,
Nice.
it
So
really comes down to sitting down with a client and finding out what they want.
so it's personalized to everyone. But I also noticed that a lot of couples, and I forget the name, they'll come in and get identical wills pointing
That's
like they get mine and you get the others or
a
whatever it is.
reciprocal will.
Yeah.
Yeah. That's very common.
Now, can they change it the next day when their spouse doesn't know?
One of the first things, if I have a couple come in and they want to talk about an estate plan for the both of them, one of the first things I ask them is, are we going to be doing this together?
Mm-hmm.
Uh,
But technically, they could. They could say, "Yeah, I want to leave it to them," and then the next day
yeah,
they
oh
could
yeah,
go and change it, right?
yep,
Yeah.
absolutely. And I've had people. I think my record is, I've done a will, and I think like less than a month and a half later, person's calling up and got upset with one of the people and said, I want to scrap it. You
Oh
know,
wow. Yeah.
so
Start over.
so we started over, and it happens. But uh, where we see a lot of the reciprocal stuff with first time marriages.
Mm-hmm.
If you're talking about a subsequent marriage, then you have to be careful, okay? Because especially if both parties had children
Yeah.
from the first marriage,
Right.
that can get to be sticky because in a reciprocal marriage, a lot of times you got two young kids coming in, they're 22, 23, 24, they just got married. Oh, I'm leaving everything to my wife, or I'm leaving everything to my husband. Okay, great. 10 years down the line, they're divorced. They both get remarried. By now, they both have two kids apiece.
Yeah.
Now, okay, I'm bringing this amount in, and that's where you start talking about antenuptial or prenup agreements.
Yeah.
I want my stuff to go to my kids,
Mm-hmm.
um, But then again, some say, we're raising them as brothers and sisters and as a family, and we want it divided. Let's say you got 4 kids total. We want it divided 4 ways. Okay, fine. I mean, again, it's what you want. But one of the things that I think um, attorneys that do estate planning, what they really need to focus on is making sure they get enough information out to the client so that they can make an informed decision as opposed to just doing what they've heard or what they may have seen on TV,
Right.
that kind of stuff.
Well, I hate to do this, but we have 2 minutes. So tell us where we can find you.
Oh, well, it's Stephen Douglas Law Office, PC. Our phone number is 812-369-4435. Email sdouglaslaw@gmail.com. We do have a Facebook presence, and our office is located at 1451 West Arlington Road, Flemington 47404.
Well, it was so nice for you to take your time out today. I feel so honored. Thank you so much. I appreciate you as always.
Thank you, Michelle. I appreciate the opportunity.
We haven't had our once a year lunch yet, so we got to get that scheduled soon.
That's probably my fault because
No.
God bless them. My kids keep churning out grandkids. So
That's wandonderful. Keep
so,
those genes going. Well,
well,
thank you.
you're welcome.
I love your grand picture babies, grandbaby pictures that you send me. So I appreciate that. They're beautiful.
Thank you.
God bless. Thanks. I love you.
Bye.
See you later. Bye.